Question 1. The monitoring system demonstrates that a client has failed to settle outstanding fees for services rendered by the firm. The firm's internal review confirms the debt is valid and undisputed. What is the most appropriate course of action for the firm to pursue legal action for recovery, adhering strictly to UK regulatory frameworks and ethical obligations? Option A. Cease all communication with the client and immediately write off the debt as unrecoverable. Option B. Unilaterally seize client assets held by the firm to offset the outstanding fees without prior legal authorization. Option C. Employ aggressive collection tactics, including frequent and demanding calls, to pressure the client into immediate payment. Option D. Initiate formal legal proceedings through the appropriate court channels to seek a judgment for the outstanding debt. The correct answer is D. Initiate formal legal proceedings through the appropriate court channels to seek a judgment for the outstanding debt. Explanation. This scenario is professionally challenging because it requires a firm to navigate the complex legal landscape of recovering funds from a client who has defaulted on payments, while strictly adhering to the regulatory framework governing financial services in the UK, specifically as it pertains to the Liability Technical Certification exam. The firm must balance its right to recover outstanding fees with its obligations to treat customers fairly and to act with integrity, as mandated by the Financial Conduct Authority, FCA, and relevant legislation. The decision-making process must be grounded in a thorough understanding of legal recourse available, the limitations imposed by consumer protection laws, and the ethical considerations inherent in debt recovery. Correct approach involves initiating formal legal proceedings for debt recovery, which is a structured and regulated process. This approach is right because it aligns with the legal framework for recovering debts owed by clients. By pursuing legal action, the firm is utilizing established judicial mechanisms to seek a resolution, which typically involves a court order for payment. This process ensures that the recovery efforts are conducted within the bounds of the law, providing a clear and documented pathway for resolution. It also offers the client an opportunity to present any defenses or counterclaims within a formal legal setting, upholding principles of natural justice. This aligns with the FCA's principles for businesses, particularly Principle 7, Communications with Clients, and Principle 8, Utmost Good Faith. By ensuring that communication regarding the debt and the recovery process is clear, fair, and transparent, and that the firm acts with integrity, an incorrect approach would be to engage in aggressive or misleading communication tactics to pressure the client into immediate payment. This is ethically and regulatorily unacceptable because it can constitute unfair treatment and potentially breach FCA rules on treating customers fairly. Such tactics can cause undue distress and may not accurately reflect the client's legal obligations or rights. Another incorrect approach would be to unilaterally seize or offset client assets without a clear legal basis or prior agreement. This action could be construed as unlawful seizure or conversion, leading to significant legal repercussions for the firm and a breach of its duty to act with integrity and in accordance with the law. Furthermore, it would likely violate consumer protection legislation designed to prevent predatory practices. A third incorrect approach would be to cease all communication and write off the debt without exploring any legitimate recovery avenues. While this might seem like an easy solution, it fails to uphold the firm's responsibility to its stakeholders and could be seen as a dereliction of duty if the debt is substantial and recovery is feasible through lawful means. It also misses the opportunity to recover funds that are rightfully owed. The professional decision-making process for similar situations should involve a systematic evaluation of the debt, the client's circumstances, where legally permissible to consider, and the available legal and regulatory options. This includes 1. Documenting the outstanding debt and the services provided. 2. Reviewing the client agreement for terms related to payment and default. 3. Consulting with legal counsel to understand the most appropriate and lawful recovery methods. 4. Communicating with the client in a clear, fair, and compliant manner regarding the outstanding debt and potential next steps. 5. Initiating formal legal action if other avenues are exhausted and deemed appropriate, ensuring all actions are conducted in strict accordance with UK law and FCA regulations. Question 2. The evaluation methodology shows that a liability insurance policy has been issued to a contractor. An endorsement is attached which names a property owner as an additional insured, but states that coverage for the additional insured is limited to liability arising out of the named insured's operations performed for the additional insured. A subsequent claim is made against the property owner for a breach of contract unrelated to the contractor's work on the property. Which approach best reflects the correct application of the endorsement and regulatory expectations? Option A. The insurer should provide coverage to the property owner for the breach of contract claim, as they are listed as an additional insured. Option B. The insurer should deny coverage for the breach of contract claim because the endorsement limits coverage to liability arising out of the named insured's operations performed for the additional insured, and the claim is unrelated to those operations. Option C. The insurer should advise the property owner to seek coverage under their own separate liability insurance policy, as the endorsement is intended for direct operational liabilities only. Option D. The insurer should offer a partial coverage settlement to the property owner, acknowledging their status as an additional insured, but recognizing the claim's tenuous link to the contractor's work. Correct answer is A. The insurer should provide coverage to the property owner for the breach of contract claim, as they are listed as an additional insured. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of how endorsements modify the fundamental terms of a liability insurance policy, specifically concerning the scope of coverage for parties other than the named insured. The challenge lies in accurately interpreting the intent and legal effect of such endorsements within the strict confines of the policy wording and applicable regulatory guidance, ensuring that coverage is neither inadvertently expanded nor unfairly restricted. The correct approach involves meticulously reviewing the specific wording of the additional insured endorsement and cross-referencing it with the policy's general terms and conditions, as well as relevant UK regulatory guidance on policy interpretation and fair treatment of customers. This approach is correct because it prioritizes a precise, literal interpretation of the endorsement's language, ensuring that the additional insured's coverage is limited to the liability arising from the named insured's operations, as is standard practice, and aligns with the principle of indemnity. This adheres to regulatory expectations that policy terms are clear, unambiguous, and applied consistently. An incorrect approach would be to assume that an additional insured endorsement grants blanket coverage to the additional insured for all their liabilities, irrespective of their connection to the named insured's operations. This is an incorrect approach because it misinterprets the fundamental purpose of such endorsements, which is to extend coverage only for liabilities stemming from the named insured's actions or omissions. This failure to adhere to the specific limitations of the endorsement could lead to regulatory breaches related to misrepresentation or unfair claims handling, as it would imply coverage that was not intended or priced for. Another incorrect approach would be to unilaterally broaden the scope of coverage for the additional insured based on a perceived business relationship or a general understanding of industry practice, without explicit endorsement language to support it. This is incorrect because it bypasses the contractual agreement of the policy and the specific terms of the endorsement. Such an action would violate regulatory principles of adhering to policy terms and could expose the insurer to unintended liabilities, potentially leading to sanctions for acting outside the scope of the policy and regulatory guidelines. The professional decision-making process for similar situations should involve a systematic review of the policy and all endorsements. This includes understanding the specific definitions within the policy, the operative clauses, and the precise language of any endorsements. When faced with ambiguity, professionals should consult internal legal or underwriting expertise and refer to relevant regulatory guidance on policy interpretation and consumer protection. The ultimate goal is to apply the policy as written, ensuring fairness to all parties, while remaining compliant with regulatory requirements. Question 3. The assessment process reveals that a financial advisor is meeting with a highly distressed client who has become increasingly agitated during the discussion about investment performance. The client begins to raise their voice, clench their fists, and lean aggressively across the desk, making the advisor feel physically threatened. What is the most appropriate course of action for the financial advisor in this situation? Option A. Attempt to de-escalate the situation through calm communication and discreetly signal for security assistance. Option B. Physically restrain the client to prevent them from becoming more aggressive. Option C. Immediately end the meeting and ask the client to leave the premises without involving any other staff. Option D. Continue the meeting as planned, hoping the client's emotions will subside on their own. Correct answer is A. Attempt to de-escalate the situation through calm communication and discreetly signal for security assistance. Explanation. This scenario is professionally challenging because it pits a financial advisor's duty to their client against the potential for a physical altercation, which carries significant legal and ethical ramifications. The advisor must navigate a situation where a client's emotional distress could escalate to a point of physical harm, requiring immediate and appropriate action without overstepping professional boundaries or creating further liability. The core challenge lies in de-escalating the situation and ensuring safety while adhering to professional conduct and regulatory expectations. The correct approach involves prioritizing de-escalation and seeking assistance from appropriate personnel. This approach is right because it directly addresses the immediate threat of physical harm by attempting to calm the client and, crucially, by involving security. This aligns with the overarching regulatory duty of care and the ethical imperative to protect oneself and others from harm. The regulatory framework, particularly concerning professional conduct and client interaction, implicitly requires advisors to manage difficult client situations responsibly, which includes preventing physical altercations. Seeking security intervention is a standard and accepted professional practice for managing potentially violent individuals in a regulated environment, thereby mitigating risk for all parties involved and upholding the integrity of the professional setting. An incorrect approach that involves physically restraining the client is professionally unacceptable. This action could lead to accusations of assault and battery, creating significant legal liability for the advisor and the firm. Ethically, it violates the principle of non-maleficence, as the advisor is not trained in physical restraint and could cause injury. Furthermore, it escalates the situation rather than de-escalating it, directly contradicting the duty to act in the best interest of all parties. Another incorrect approach, which is to ignore the client's aggressive behavior and continue the meeting, is also professionally unacceptable. This demonstrates a failure to recognize and address a clear and present danger, violating the duty of care. It exposes the advisor, the client, and potentially others to harm. Ethically, it is a dereliction of duty to allow a situation to deteriorate to the point of potential physical violence. This inaction could be construed as negligence, leading to regulatory sanctions and civil liability. The professional decision-making process for similar situations should involve a rapid assessment of the threat level, prioritizing de-escalation techniques, and knowing when to disengage and seek external help, such as security or management. Professionals must be trained to recognize escalating behavior and have clear protocols for responding to such incidents. The guiding principle should always be the safety of all individuals involved, followed by adherence to regulatory requirements and ethical standards. Question 4. What factors determine the extent to which a commercial general liability (CGL) policy will respond to an alleged product liability claim, considering the interplay of insuring agreements, exclusions, and relevant judicial interpretations within the governing jurisdiction? Option A. The subjective belief of the insured regarding the policy's coverage and the insurer's desire to minimize claim payouts. Option B. The plain language of the CGL policy's insuring agreements, the specific wording and applicability of all relevant exclusions, and the interpretation of such provisions by courts in the governing jurisdiction. Option C. A general understanding of product liability principles without specific reference to the CGL policy wording or applicable case law. Option D. The perceived marketability of the insured's product and the potential impact of a claim on the insurer's overall financial reserves. The correct answer is B. The plain language of the CGL policy's insuring agreements, the specific wording and applicability of all relevant exclusions, and the interpretation of such provisions by courts in the governing jurisdiction. Explanation. This scenario is professionally challenging because determining the scope of coverage under a commercial general liability (CGL) policy requires a nuanced understanding of policy language, relevant case law, and the specific facts of a claim. It is not a purely mechanical process, but demands careful judgment to balance the insured's expectation of coverage with the insurer's contractual obligations and financial prudence. The interplay between insuring agreements, exclusions, conditions, and definitions necessitates a thorough and objective analysis. The correct approach involves a comprehensive review of the CGL policies, insuring agreements to identify if the alleged harm falls within the broad categories of coverage, e.g., bodily injury, property damage, personal and advertising injury. Subsequently, all relevant exclusions must be meticulously examined to ascertain if any apply to negate coverage. If exclusions are ambiguous or their application is contested, the policy's definitions and any applicable endorsements or amendments must be considered. Finally, the analysis must be informed by relevant judicial interpretations of similar policy language within the governing jurisdiction. This approach is correct because it systematically applies the contractual terms of the insurance policy and adheres to established legal principles for contract interpretation, ensuring that coverage decisions are both legally sound and ethically defensible, aligning with the duty of good faith and fair dealing owed to the insured. An incorrect approach would be to solely rely on the insured's initial assertion of a claim, without independently verifying the facts and policy applicability. This fails to uphold the insurer's responsibility to underwrite risk and can lead to unwarranted payouts, potentially impacting premium rates for all policyholders. Another incorrect approach is to broadly interpret exclusions to deny coverage whenever possible, without considering the plain meaning of the insuring agreements or the reasonable expectations of the insured. This can violate the principle that insurance policies are contracts of adhesion and ambiguities are typically construed against the insurer. Furthermore, ignoring relevant case law or applying interpretations from other jurisdictions would be a significant regulatory and ethical failure, as coverage is governed by the specific policy language and the laws of the jurisdiction where the policy is in force. Professionals should employ a structured decision-making process that begins with a thorough understanding of the claim facts. This is followed by a detailed examination of the applicable CGL policy, paying close attention to insuring agreements, exclusions, definitions, and endorsements. The next step involves researching and applying relevant case law from the governing jurisdiction to interpret ambiguous terms or disputed applications of policy provisions. This systematic and legally informed process ensures that coverage decisions are consistent, fair, and compliant with regulatory requirements and ethical obligations. Question 5. Examination of the data shows that a financial advisor recommended a high-risk investment strategy to a client. The client, after being provided with detailed documentation outlining the significant potential for capital loss and volatility, explicitly confirmed their understanding of these risks and expressed a desire to proceed with the strategy due to its potential for high returns. The investment subsequently experienced substantial losses. The client is now considering a claim against the advisor for negligence, which defense is most likely to provide a complete bar to the client's claim. Option A, comparative negligence. Option B, mitigation of damages. Option C, assumption of risk. Option D, contributory negligence. The correct answer is C, assumption of risk. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of how different defenses to negligence interact and can impact the outcome of a claim, particularly in the context of financial advice. A financial advisor must not only identify potential negligence, but also anticipate how the client's own actions or awareness might mitigate or eliminate liability. Careful judgment is required to apply the correct legal principles to the specific facts presented. The correct approach involves recognizing that the client's explicit acknowledgement of the risks associated with a particular investment strategy, coupled with their decision to proceed despite understanding those risks, strongly suggests the defense of assumption of risk. This defense, when successfully argued, can completely bar recovery for the plaintiff. In the UK regulatory framework, particularly as it pertains to financial services, demonstrating that a client understood and accepted the inherent risks of an investment, even if it subsequently underperformed, can be a complete defense to a claim of negligence. This aligns with the principle that professionals are not insurers against all possible outcomes, but rather owe a duty of care to provide suitable advice and information. An incorrect approach would be to solely focus on contributory negligence. While contributory negligence considers the client's own fault in contributing to their loss, it typically leads to a reduction in damages rather than a complete bar to recovery. If the advisor's negligence is established, and the client's actions are seen as merely contributing to the loss, damages would be apportioned. This fails to acknowledge the potential for a complete defense if the client's awareness and acceptance of risk were sufficiently informed and voluntary. Another incorrect approach would be to focus on comparative negligence. Comparative negligence, as understood in some jurisdictions, apportions fault between the plaintiff and defendant, reducing damages proportionally. However, in the UK context relevant to this exam, the primary defenses are contributory negligence and assumption of risk. Relying on a comparative negligence framework, which is not the dominant legal principle in this jurisdiction for negligence claims, would be a fundamental error. Furthermore, even within a comparative framework, it might not fully capture the essence of the client's informed acceptance of risk, which can be a complete defense. The professional decision-making process for similar situations should involve a systematic evaluation of the client's actions and understanding. First, determine if a breach of the duty of care has occurred. Second, assess the client's contribution to their loss, contributory negligence. Third, critically evaluate whether the client fully understood and voluntarily accepted the specific risks inherent in the advice or investment, assumption of risk. If assumption of risk is clearly established, it should be considered a complete defense. If not, then contributory negligence may be considered to reduce damages. The advisor must always operate within the established legal and regulatory framework of the relevant jurisdiction. Question 6. When evaluating an insurance policy that states it is following form to a specific master policy, and the following form policy document itself contains several exclusions and conditions, what is the most appropriate approach to determining the full scope of coverage and obligations? Option A. Interpret the following form policy by incorporating the terms and conditions of the referenced master policy, as the following form designation implies adherence to the master policy structure and intent. Option B. Treat the following form policy document as a self-contained contract, applying only its stated exclusions and conditions. Option C. Apply the exclusions and conditions from the following form policy document unless they directly contradict the master policy, in which case the following form policy's terms take precedence. Option D. Assume the following form policy is intended to provide broader coverage than the master policy, and therefore prioritize its stated terms over any potentially conflicting provisions in the master policy. Correct answer is B. Treat the following form policy document as a self-contained contract, applying only its stated exclusions and conditions. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of insurance policy construction and the potential for ambiguity to lead to disputes and financial loss. The core difficulty lies in determining the governing terms when a policy is not entirely self-contained, necessitating a decision on whether to rely solely on the policy document itself or to incorporate external documents. This decision has significant implications for coverage, risk assessment, and regulatory compliance. The correct approach involves carefully reviewing the policy wording to ascertain if it explicitly incorporates or references other documents as part of the contract. If the policy clearly states that it is following form and specifies the underlying or master policy it is intended to mirror, then it is professionally sound and ethically imperative to treat the referenced documents as integral to the policy's terms and conditions. This approach aligns with the principle of fulfilling the contractual intent of the parties. Regulatory frameworks, such as those governing insurance contracts, generally uphold the enforceability of terms that are clearly incorporated by reference, provided this incorporation is unambiguous and understood by the insured. Adhering to this principle ensures that the policy accurately reflects the agreed-upon coverage and obligations, thereby promoting fairness and preventing misrepresentation. An incorrect approach would be to solely rely on the following form policy document, without considering the referenced underlying or master policy. This failure to incorporate the referenced documents would lead to an incomplete understanding of the coverage and exclusions, potentially resulting in underwriter errors, mispriced risks, and ultimately, disputes over claims. Ethically, this would be a dereliction of duty, as it fails to uphold the full contractual agreement. From a regulatory perspective, it could be seen as a failure to adhere to proper underwriting and policy administration standards, potentially violating principles of fair dealing and accurate representation of policy terms. Another incorrect approach would be to arbitrarily decide to treat the following form policy as self-contained, ignoring any explicit references to other documents. This would be a misinterpretation of the policy structure and intent. It would lead to an inaccurate assessment of risk and coverage, potentially exposing the insurer to liabilities not contemplated in the original underwriting, or leaving the insured with less coverage than they believed they had. This approach violates the fundamental principle of contract law that parties are bound by the terms they have agreed to, including those incorporated by reference. It also risks regulatory scrutiny for misrepresenting policy terms and failing to provide accurate information to policyholders. The professional decision-making process for similar situations should begin with a thorough examination of the policy's language. The professional must identify any clauses that indicate the policy is following form or that explicitly incorporate other documents by reference. If such clauses exist, the next step is to obtain and review the reference documents to understand their content and how they modify or supplement the following form policy. This diligent review ensures that the policy is interpreted and administered in accordance with the parties' intentions and regulatory requirements. The professional must prioritize clarity and accuracy in understanding the complete contractual obligations. Question 7. Compliance review shows that following a minor incident on the insured's property, an injured guest occupant incurred medical expenses. The insured has coverage C, medical payments. The insurer's claims adjuster, aiming for a swift resolution and to maintain good relations, is considering offering a payment to the injured party to cover their immediate medical bills, but is unsure if this action could be misconstrued as an admission of liability for the incident itself. What is the most appropriate approach for the insurer in this situation? Option A. Offer a payment to the injured party specifically designated as a medical payments coverage benefit, clearly communicating that this payment is made on a no-fault basis under coverage C and does not constitute an admission of liability for any other aspect of the incident. Option B. Advise the insured to personally pay the injured party's medical bills and then seek reimbursement from the insurer under coverage C to avoid any direct insurer involvement that could be perceived as liability. Option C. Deny coverage for the medical expenses, stating that the incident's circumstances require further investigation into fault before any payments can be considered. Option D. Offer a lump sum payment to the injured party as a full and final settlement of all potential claims arising from the incident, including medical expenses, without a formal release. The correct answer is A. Offer a payment to the injured party specifically designated as a medical payments coverage benefit, clearly communicating that this payment is made on a no-fault basis under coverage C and does not constitute an admission of liability for any other aspect of the incident. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of coverage C, medical payments, and its application in a situation involving potential liability. The core challenge lies in distinguishing between payments made under coverage C, which are typically no fault, and those that might be construed as an admission of liability or a settlement of a claim, which could have significant implications for the insurer's defense and future obligations. Careful judgment is required to ensure that the insurer acts in good faith and adheres to policy terms and regulatory requirements. The correct approach involves a thorough investigation to determine if the incident falls within the scope of coverage C, specifically focusing on whether the injured party was a guest occupant or on the insured premises with permission. If the facts support coverage under coverage C, the insurer can proceed with making a payment under this provision, which is designed to cover reasonable medical expenses incurred regardless of fault. This approach is ethically and regulatorily sound because it upholds the contractual obligations of the policy, provides prompt relief to the injured party for medical expenses, and avoids prejudicing the insurer's position on liability for other potential claims. The regulatory framework for insurance mandates that insurers act in good faith and honor their policy commitments. An incorrect approach would be to immediately deny coverage without a proper investigation. This failure to investigate is a breach of the duty of good faith and fair dealing, which is a fundamental regulatory and ethical obligation. It can lead to accusations of unfair claims settlement practices. Another incorrect approach would be to offer a payment that is framed as a settlement of the entire claim, including potential pain and suffering or other damages, without a formal release or a clear understanding that this payment is solely for medical expenses under coverage C. This could inadvertently create an admission of liability or a premature settlement, potentially waiving the insurer's right to investigate further or defend against other claims. This violates the principle of acting within the defined scope of the policy and could expose the insurer to greater financial risk and regulatory scrutiny for improper claims handling. The professional decision-making process for similar situations should involve 1. Information gathering, Conduct a prompt and thorough investigation to ascertain all relevant facts surrounding the incident. 2. Policy interpretation. Carefully review the policy language, particularly the definitions and exclusions related to coverage C, medical payments. 3. Coverage determination. Based on the gathered facts and policy interpretation, determine if the incident and the injured party's expenses qualify for coverage under coverage C. 4. Communication. Clearly communicate the coverage determination and the basis for it to all relevant parties. 5. Action. If coverage is confirmed, proceed with making payments strictly in accordance with the terms of coverage C, ensuring that such payments are not presented as an admission of fault or a settlement of the entire claim, unless explicitly agreed upon with appropriate documentation. Question 8. The evaluation methodology shows that a commercial client, operating a small manufacturing plant, experienced a leak from a storage tank containing a specialized industrial solvent. The solvent seeped into the soil and subsequently contaminated a nearby stream, causing harm to aquatic life. The client states they regularly inspected the tank and the leak was unforeseen. The policy in question contains exclusions for expected or intended injury and pollution. The client is seeking coverage for the cleanup costs and damages. Which of the following approaches best aligns with the regulatory framework and guidelines for determining coverage in this scenario? Option A. Deny coverage under the pollution exclusion because an industrial solvent was released into the environment, and deny coverage under the expected or intended injury exclusion because the client's manufacturing operations inherently carry a risk of such releases. Option B. Deny coverage under the expected or intended injury exclusion, arguing that any industrial operation carries an inherent risk of environmental damage, and deny coverage under the pollution exclusion due to the nature of the substance, regardless of the leak's circumstances. Option C. Grant full coverage immediately, as the client claims the leak was unforeseen and they regularly inspected the tank, implying a lack of intent to cause harm or pollution. Option D. Investigate whether the industrial solvent meets the policy's definition of a pollutant and whether the release was sudden and accidental, while also assessing whether the client subjectively expected or intended the specific harm to aquatic life or the contamination of the stream, rather than just the act of manufacturing. Correct answer is A. Deny coverage under the pollution exclusion because an industrial solvent was released into the environment, and deny coverage under the expected or intended injury exclusion because the client's manufacturing operations inherently carry a risk of such releases. Explanation. This scenario presents a professional challenge due to the nuanced application of policy exclusions, specifically the expected or intended injury and pollution clauses, in a situation where the causal link between the insured's actions and the resulting damage is not immediately obvious. The insured's intent and the foreseeability of the consequences are critical factors that require careful interpretation of the policy language and relevant case law. Professionals must navigate the potential for ambiguity and the insured's desire for coverage against the insurer's obligation to uphold the policy's contractual limitations. The correct approach involves a thorough investigation into the insured's knowledge and actions leading up to the incident. This includes gathering evidence to determine if the injury or damage was a direct and foreseeable result of the insured's deliberate acts or omissions, or if it was an accidental consequence of otherwise lawful activities. Specifically, for the expected or intended injury exclusion, the focus is on whether the insured expected or intended the specific harm that occurred, not merely whether they intended the act that led to the harm. For the pollution exclusion, the analysis must consider whether the substance released constitutes pollutant as defined by the policy, and whether the release was sudden and accidental or gradual and expected. Applying these principles requires a deep understanding of the policy's wording and relevant legal precedents that define expected, intended, and pollutant. An incorrect approach would be to automatically deny coverage based on a superficial understanding of the incident. For instance, assuming that any release of a chemical substance automatically triggers the pollution exclusion without examining the policy's definition of pollutant or the circumstances of the release would be a regulatory failure. Similarly, denying coverage under the expected or intended injury exclusion simply because the insured performed an action that could have led to injury, without demonstrating that the insured expected or intended that specific injury, would be a misapplication of the exclusion and a potential breach of good faith. Another incorrect approach would be to rely on external industry standards or common law interpretations that are not directly applicable to the specific policy wording and the governing jurisdiction's regulatory framework. Professionals should employ a structured decision-making process that begins with a comprehensive review of the insurance policy, paying close attention to the definitions and wording of all exclusions. This should be followed by a detailed factual investigation, gathering all relevant documentation and witness statements. The findings should then be analyzed against the specific policy language and applicable regulatory guidance and case law within the governing jurisdiction. If ambiguity remains, seeking legal counsel or consulting with senior claims professionals is advisable before making a coverage determination. The ultimate decision must be based on a good faith interpretation of the policy and adherence to regulatory requirements. Question 9. Regulatory review indicates that a complex liability claim may be covered under both a general liability policy and a professional indemnity policy held by the same insured. The general liability policy contains an other insurance clause stating it is excess over any other valid and collectible insurance. The professional indemnity policy states it will pay for loss arising from the rendering of professional services. Which approach best ensures compliance with regulatory expectations for claims handling and policy interpretation? Option A. The general liability insurer should be considered primary as its policy is more comprehensive in scope. Option B. A detailed analysis of the other insurance clauses in both policies should be conducted to determine which policy is intended to be primary or excess. Option C. The professional indemnity insurer should be considered primary as the claim directly relates to the rendering of professional services. Option D. The loss should be shared equally between both insurers until a definitive agreement is reached. The correct answer is A. The general liability insurer should be considered primary as its policy is more comprehensive in scope. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of how different liability policies interact, particularly when a claim potentially triggers coverage under multiple policies. The core difficulty lies in accurately identifying the primary insurer and the extent of each insurer's obligations without creating coverage gaps or unfairly burdening one party. Misinterpretation can lead to disputes, delays in claim resolution, and potential financial repercussions for the insured and insurers alike. The professional must navigate complex policy wordings, endorsements, and the principle of indemnity to ensure fair and compliant outcomes. Correct approach analysis. The correct approach involves a thorough review of all relevant liability policies, focusing on their respective insuring agreements, definitions of occurrence or accident, and crucially, their other insurance clauses. The primary insurer is typically identified by the policy that responds first, often determined by wording that states it will pay if no other valid and collectible insurance is available, or by a pro rata clause that shares the loss equally with other applicable insurance. The professional must then ascertain if the identified primary policy is indeed the first in line of coverage based on its specific wording and the nature of the claim. This methodical, policy-driven analysis ensures adherence to contractual obligations and regulatory expectations for fair claims handling. Incorrect approaches analysis. An incorrect approach would be to assume the most recently issued policy is the primary insurer. This ignores the contractual primacy established by the other insurance clauses within each policy, which dictate the order of payment regardless of policy issuance date. Such an assumption could lead to the wrong insurer bearing the initial burden, potentially violating the terms of their policy and leading to disputes. Another incorrect approach is to simply divide the loss equally among all potentially involved insurers without first determining which policy is primary. This fails to respect the hierarchy established by other insurance clauses, particularly excess clauses which state a policy will only respond after other applicable insurance has been exhausted. This can result in an insurer that should be excess paying a portion of the primary loss, which is a direct contravention of its policy terms. Finally, an incorrect approach is to delay the claim investigation and coverage determination until all parties have agreed on the order of liability. While cooperation is ideal, the professional has a duty to investigate and determine coverage based on the policy terms and the facts of the claim. Unnecessary delays in identifying the primary insurer and initiating payment can lead to regulatory sanctions for unfair claims practices and prejudice the insured. Professional reasoning. Professionals should approach such situations by first meticulously examining the claim facts to determine the date and nature of the loss. Subsequently, they must conduct a detailed review of each potentially applicable liability policy, paying close attention to the other insurance provisions. The goal is to identify the policy that, by its own terms, is intended to respond first. If multiple policies appear to be primary, a comparative analysis of their other insurance clauses is necessary to resolve the order of coverage. This systematic, policy-centric approach, grounded in the contractual language and regulatory requirements for fair claims handling, ensures that the correct insurer is identified and that the insured receives prompt and appropriate indemnity. Question 10. The efficiency study reveals that a significant portion of claims are taking longer than the industry average to close, impacting operational costs. One of the proposed solutions is to implement a policy where claims handlers are incentivized to settle claims within 48 hours of initial notification, regardless of the complexity or the need for further investigation, by offering a bonus for meeting this target. This approach is expected to reduce the average claims handling time by 30%. What is the most appropriate course of action for a claims handler in this situation? Option A. Inform policyholders that all claims will now be settled within 48 hours, managing their expectations about the depth of investigation. Option B. Advocate for a revised incentive structure that rewards timely and fair claim resolution, emphasizing thorough investigation and accurate settlement while still encouraging efficient processes. Option C. Focus solely on closing claims within 48 hours, even if it means settling for a lower amount than the policyholder is entitled to maximize personal bonus potential. Option D. Immediately adopt the 48-hour settlement policy to meet the efficiency targets and secure the incentive bonus, as this is a directive from the efficiency study. The correct answer is B. Advocate for a revised incentive structure that rewards timely and fair claim resolution, emphasizing thorough investigation and accurate settlement, while still encouraging efficient processes. Explanation. This scenario presents a professional challenge because it pits the desire for operational efficiency and cost reduction against the fundamental duty of fair and timely claims handling. The pressure to meet targets can lead to a temptation to expedite processes in ways that compromise thoroughness and fairness to the policyholder. Careful judgment is required to balance business objectives with regulatory obligations and ethical responsibilities. The correct approach involves prioritizing the policyholder's needs and ensuring a thorough, fair, and timely investigation and settlement of the claim, even if it means deviating from the most cost-effective or quickest internal process. This aligns with the regulatory framework's emphasis on treating customers fairly and handling claims with due skill, care, and diligence. Specifically, regulations often mandate that insurers act in good faith, investigate claims promptly and thoroughly, and provide clear communication. Expediting a claim without adequate investigation, even if it results in a payout, could still be considered unfair if the payout is not commensurate with the actual loss, or if the policyholder is not fully informed of their rights and entitlements. An incorrect approach would be to prioritize the efficiency study's recommendations for faster claim closure above all else, potentially leading to under-investigation or pressure on claims handlers to settle quickly without full consideration of the evidence. This could result in claims being settled for less than they are worth, or in the denial of legitimate claims due to insufficient investigation. Such actions would likely breach regulatory requirements concerning fair treatment of customers and the duty to investigate claims properly. Another incorrect approach would be to ignore the efficiency study entirely and continue with potentially inefficient processes, failing to meet obligations for timely claims handling and potentially incurring unnecessary costs that could impact policyholder premiums in the long run. This would fail to uphold the duty of acting with due skill and care in managing the business. Professionals should approach such situations by first understanding the underlying intent of the efficiency study to improve service and potentially reduce costs without compromising quality. They should then critically evaluate each recommendation, against their regulatory and ethical obligations. If a recommendation appears to conflict with these duties, the professional must advocate for an alternative that achieves efficiency without sacrificing fairness or thoroughness. This involves clear communication with management, referencing specific regulatory requirements, and proposing solutions that balance all stakeholder interests. Question 11. System analysis indicates a client operating an online retail business is concerned about a cease and desist letter received from a competitor. The competitor alleges that the client's recent online advertisements, which feature product comparisons and highlight perceived deficiencies in the competitor's offerings, constitute defamation and disparagement. The client insists their advertisements were truthful and intended to highlight superior product features, and that any negative portrayal of the competitor was unintentional. The client is seeking confirmation that their existing liability policy, specifically Coverage B, personal and advertising injury liability, will cover any potential legal defense costs and damages arising from this dispute. Option A. Recommend the client immediately remove all comparative advertising and issue a public retraction to avoid any potential claim, stating that such actions would likely preclude any coverage under Coverage B. Option B. Inform the client that since they claim the negative portrayal was unintentional and their intent was to highlight product superiority, Coverage B does not apply as there was no malicious intent to defame or disparage. Option C. Advise the client that Coverage B will likely apply, as the allegations of defamation and disparagement, if proven, fall within the definition of personal and advertising injury, and that the insurer will provide a defense and indemnify for covered damages, subject to policy terms and conditions. Option D. Advise the client that Coverage B is designed for intentional acts and therefore will not cover any allegations of defamation or disparagement, regardless of the specific circumstances or policy definitions. The correct answer is C. Advise the client that Coverage B will likely apply, as the allegations of defamation and disparagement, if proven, fall within the definition of personal and advertising injury, and that the insurer will provide a defense and indemnify for covered damages, subject to policy terms and conditions. Explanation. This scenario presents a professional challenge due to the inherent conflict between a client's desire to minimize perceived liability and the insurer's obligation to accurately assess coverage based on policy terms and applicable regulations. The core difficulty lies in interpreting the scope of personal and advertising injury in the context of evolving digital marketing practices and potential misrepresentations. Careful judgment is required to ensure that the policy's intent is upheld, while also considering the nuances of modern advertising. The correct approach involves a thorough review of the policy's Coverage B wording, specifically the definitions of personal and advertising injury, and any exclusions that might apply. This must be coupled with an understanding of the relevant regulatory framework governing advertising and intellectual property within the specified jurisdiction. The insurer must then objectively determine if the client's actions, as described, fall within the scope of covered offenses, such as libel, slander, or infringement of copyright, in the context of their online advertising. This approach is correct because it adheres to the contractual obligations of the insurance policy and the legal and regulatory requirements of the jurisdiction. It prioritizes an objective assessment of facts against policy terms and applicable law, ensuring fair treatment of the insured while protecting the insurer's interests. An incorrect approach would be to automatically deny coverage based solely on the client's assertion that their actions were unintentional or that the competitor's claims are exaggerated. This fails to engage in the necessary analytical process to determine if the alleged injury, even if disputed by the insured, could potentially fall under the policy's coverage. Another incorrect approach would be to accept the client's interpretation of the policy without independent verification or consideration of regulatory guidance. This risks misinterpreting the policy and potentially providing coverage where none exists, or conversely, unfairly denying coverage that is warranted. A third incorrect approach would be to advise the client on how to rephrase their advertising to avoid potential claims without first assessing the existing coverage. This could be construed as assisting in circumventing policy terms or engaging in potentially misleading advice, which is ethically and regulatorily problematic. Professionals should employ a decision-making framework that begins with a clear understanding of the policy language and the specific facts presented. This should be followed by research into relevant case law and regulatory interpretations within the governing jurisdiction concerning personal and advertising injury. The objective is to apply the policy terms to the facts in a manner consistent with legal and regulatory requirements. If there is ambiguity, the professional should seek clarification from legal counsel or underwriting, rather than making assumptions or providing advice that could lead to coverage disputes or regulatory noncompliance. Question 12. The efficiency study reveals that the current process for obtaining witness statements in internal investigations is time-consuming. To expedite matters, the team proposes to create summary notes of witness interviews and have these notes signed by the witnesses without providing them with a full transcript or an opportunity to review and amend the notes. What is the most appropriate course of action to ensure compliance with regulatory expectations and ethical standards? Option A. Ensure that all witness statements are recorded accurately, provided to the witness for review and confirmation, and formally signed, even if it requires more time. Option B. Proceed with the proposed summary notes, as efficiency is a key objective and the signatures will validate the content. Option C. Develop a standardized template for summary notes that includes a disclaimer acknowledging that the notes are not a verbatim record, and proceed with obtaining signatures. Option D. Delegate the task of creating summary notes to junior staff to reduce the burden on senior investigators, with senior staff providing a final cursory review. Correct answer is B. Proceed with the proposed summary notes, as efficiency is a key objective and the signatures will validate the content. Explanation. This scenario presents a professional challenge because it requires balancing the need for thoroughness in gathering evidence with the ethical and regulatory obligations concerning witness statements. The firm's reputation and the integrity of the investigation hinge on the quality and admissibility of the information obtained. Missteps in handling witness statements can lead to regulatory sanctions, reputational damage, and compromised investigative outcomes. Careful judgment is required to ensure that all statements are obtained in a manner that is both legally sound and ethically defensible. The correct approach involves ensuring that all witness statements are recorded accurately and contemporaneously, and that witnesses are informed of their rights and obligations. This includes providing them with an opportunity to review and confirm the accuracy of their statements. This aligns with regulatory expectations for due diligence and fair dealing, ensuring that evidence is reliable and that individuals are treated with respect and transparency. Adherence to these principles is crucial for maintaining the credibility of the investigation and the firm. An incorrect approach that involves summarizing witness accounts without providing an opportunity for review or confirmation risks misrepresentation or omission of crucial details. This can lead to statements that do not accurately reflect the witness's testimony, potentially undermining their evidentiary value and raising concerns about the integrity of the fact-finding process. Regulatory bodies often scrutinize the process by which evidence is gathered, and a failure to ensure accuracy in witness confirmation can be seen as a breach of professional standards. Another incorrect approach, such as relying solely on informal notes without formalizing them into signed statements, fails to create a robust and verifiable record. This leaves the firm vulnerable to challenges regarding the accuracy and completeness of the information. It also demonstrates a lack of diligence in the investigative process, which can be viewed unfavorably by regulators. Finally, an approach that involves pressuring witnesses to alter their statements to fit a desired narrative is a severe ethical and regulatory breach. This constitutes misconduct, potentially leading to disciplinary action, legal repercussions, and a complete loss of trust in the firm's investigative capabilities. It violates fundamental principles of honesty and integrity in evidence gathering. Professionals should adopt a decision-making framework that prioritizes accuracy, transparency, and compliance. This involves establishing clear protocols for obtaining and documenting witness statements, ensuring that all personnel are trained on these protocols, and conducting regular reviews to ensure adherence. When faced with situations involving witness statements, professionals should always consider the potential impact on the investigation's integrity, regulatory compliance, and ethical standing. Question 13. Research into a client's proposed investment agreement reveals several clauses that appear complex and potentially restrictive. The client asks for a clear explanation of the legal enforceability and implications of these specific clauses. What is the most appropriate course of action for the financial advisor? Option A. Advise the client to seek independent legal counsel to review the agreement and provide an interpretation of the clauses. Option B. Present the contract to the client without comment, assuming they will understand its legal ramifications. Option C. Downplay the complexity of the clauses and assure the client that they are standard and pose no significant risk. Option D. Provide a detailed personal interpretation of the legal enforceability and implications of each clause, based on general contract law knowledge. The correct answer is A. Advise the client to seek independent legal counsel to review the agreement and provide an interpretation of the clauses. Explanation. This scenario is professionally challenging because it requires a financial advisor to navigate the complexities of contract law in the context of providing advice to a client. The advisor must not only understand the client's needs, but also the legal implications of the agreements they are recommending or facilitating. Misinterpreting or misapplying contract law can lead to significant financial and reputational damage for both the client and the advisor, and potentially regulatory sanctions. Careful judgment is required to ensure that all contractual terms are understood, fair, and legally sound, and that the client is fully informed of their rights and obligations. The correct approach involves a thorough review of the proposed contract to identify any clauses that might be ambiguous, unfair, or detrimental to the client's interests, and then advising the client to seek independent legal counsel for a definitive interpretation and advice. This approach represents best professional practice because it prioritizes the client's well-being and adherence to regulatory principles that mandate acting in the client's best interest and avoiding the unauthorized practice of law. By recommending independent legal advice, the advisor ensures that the client receives expert legal interpretation of the contract, which is beyond the scope of financial advice and falls under the purview of legal professionals. This aligns with the regulatory framework's emphasis on competence and diligence, and the ethical obligation to avoid conflicts of interest or situations where the advisor may be perceived as providing legal advice. An incorrect approach would be to provide a definitive interpretation of the contract's legal implications without being a qualified legal professional. This constitutes the unauthorized practice of law, a serious regulatory and ethical breach. It exposes the client to potential harm due to a flawed understanding of their contractual obligations and rights, and it exposes the advisor to disciplinary action, fines, and potential civil liability. Another incorrect approach would be to simply present the contract to the client without any commentary or recommendation for legal review, assuming the client will understand it fully. This fails to meet the professional obligation to act in the client's best interest and provide adequate guidance. It can be seen as a dereliction of duty, as the advisor has a responsibility to ensure the client is making informed decisions, which includes understanding the legal framework of their investments. A further incorrect approach would be to dismiss the client's concerns about the contract and proceed with the transaction without addressing them. This demonstrates a lack of diligence and a failure to uphold the duty of care owed to the client. It ignores potential risks that the client has identified, which could have significant consequences. The professional decision-making process for similar situations should involve a clear understanding of the boundaries between financial advice and legal advice. When a situation touches upon legal interpretation of contractual documents, the professional should always err on the side of caution and recommend seeking advice from a qualified legal professional. This involves active listening to client concerns, identifying potential legal complexities, and proactively suggesting appropriate steps to mitigate risks, such as engaging legal counsel. Question 14. To address the challenge of accurately assessing a property damage claim involving a recent storm where a policyholder reports damage to both their roof and interior water damage, which approach best aligns with regulatory expectations for a thorough impact assessment? Option A. Rely on the policyholder's description of the damage and their estimate of repair costs for both the roof and interior, and process the claim based on this information to expedite settlement. Option B. Engage a qualified independent loss adjuster to conduct a comprehensive inspection, gather evidence of all damage types, investigate potential contributing factors to both roof and interior issues, and provide a detailed report on the scope and cause of loss. Option C. Conduct a visual inspection of the roof for obvious damage and estimate the cost of repair. Then assess the visible water stains on the interior ceilings and walls to determine the extent of interior damage. Option D. Focus the assessment primarily on the roof damage, as this is likely the primary cause of the interior water damage, and assume the interior damage is a direct and minor consequence. Correct answer is C. Conduct a visual inspection of the roof for obvious damage and estimate the cost of repair, then assess the visible water stains on the interior ceilings and walls to determine the extent of interior damage. Explanation: this scenario presents a professional challenge due to the inherent complexity of assessing property damage claims, particularly when multiple parties and potential causes are involved. The need for a thorough and objective impact assessment is paramount to ensure fair and accurate claim resolution, adhering to regulatory requirements and ethical obligations. Misjudging the impact can lead to underpayment, overpayment, or disputes, all of which carry significant consequences for both the insurer and the insured. The correct approach involves a systematic and evidence-based evaluation of the damage, considering all contributing factors and their respective impacts. This approach prioritizes a comprehensive understanding of the loss, ensuring that the assessment is not only technically sound, but also compliant with the principles of good faith and fair dealing expected of insurance professionals. Regulatory frameworks, such as those governing claims handling and consumer protection, mandate that assessments be conducted diligently and impartially, with a focus on determining the true extent of the covered loss. An incorrect approach that focuses solely on the most visible or easily quantifiable damage without investigating underlying causes or secondary effects would fail to meet these standards. Such an approach risks overlooking significant portions of the loss, leading to an incomplete and potentially unfair settlement. Ethically, this demonstrates a lack of due diligence and a failure to act in the best interests of the policyholder. Another incorrect approach that relies on assumptions or anecdotal evidence rather than objective investigation would also be professionally unacceptable. This bypasses the critical need for factual substantiation in claims assessment. Regulatory bodies often have specific guidelines on evidence required for claim validation, and a failure to adhere to these can result in compliance breaches. A third incorrect approach that prioritizes expediency over accuracy, such as settling a claim quickly based on a superficial review, would similarly fall short. While efficiency is desirable, it must not compromise the integrity of the assessment process. The regulatory expectation is for a thorough investigation that leads to a just outcome, not a rushed resolution that may be detrimental to either party. Professionals should adopt a decision-making framework that begins with a clear understanding of the policy terms and conditions. This should be followed by a meticulous collection of evidence, including expert reports, photographic documentation, and witness statements. The impact assessment should then systematically analyze each piece of evidence to determine causation and extent of damage, cross-referencing findings with policy coverage. Finally, a clear and well-documented rationale for the settlement offer should be provided to the policyholder, ensuring transparency and compliance. Question 15. Analysis of a recent High Court decision concerning the duty of care owed by financial advisors to retail clients. A financial advisor is considering how to incorporate this ruling into their client advice framework. The advisor has identified a previous, older Court of Appeal decision that addressed a similar, but not identical, factual scenario regarding advisor negligence. The advisor must determine the most appropriate method for integrating these judicial pronouncements into their ongoing client advisory practices. Option A. Conduct a detailed comparative analysis of the factual matrices and legal reasoning of both the High Court and Court of Appeal decisions to ascertain their relevance and precedential weight for the current client advisory context. Option B. Disregard the older Court of Appeal decision entirely, assuming that the more recent High Court ruling supersedes all prior case law on the subject, regardless of specific factual differences. Option C. Prioritize the older Court of Appeal decision due to its established precedent, and only consider the High Court decision if it directly contradicts the earlier ruling. Option D. Focus solely on the outcome of the High Court decision, applying its general principles to all client situations without a granular examination of the specific facts that led to that outcome. Correct answer is C. Prioritize the older Court of Appeal decision due to its established precedent, and only consider the High Court decision if it directly contradicts the earlier ruling. Explanation: This scenario presents a professional challenge due to the inherent ambiguity in interpreting and applying court decisions to novel factual circumstances. Professionals must exercise careful judgment to discern the precedential value of a ruling and its direct applicability to their client's situation, avoiding over-reliance on outdated or factually dissimilar cases. The core difficulty lies in balancing the need to leverage established legal precedent with the imperative to provide advice tailored to the unique facts at hand, all while adhering to regulatory expectations for diligence and competence. The correct approach involves a thorough analysis of the relevant court decision, identifying the core legal principles established and the specific factual context in which those principles were applied. This allows for a reasoned assessment of whether those principles and their application are directly transferable to the current client's situation. Regulatory frameworks, such as those governing financial advice or legal practice, typically mandate that professionals act with due skill, care, and diligence. This includes staying abreast of relevant case law and applying it appropriately. Ethical codes often reinforce this by requiring professionals to maintain competence and provide advice that is in the best interests of their clients, which necessitates accurate legal interpretation. An incorrect approach would be to blindly apply the outcome of a court decision without considering the factual distinctions. This fails to meet the standard of due diligence, as it ignores the crucial element of legal reasoning that links facts to outcomes. Ethically, it could lead to providing misleading advice, potentially causing harm to the client and breaching the duty of care. Another incorrect approach is to dismiss a relevant court decision simply because it is older, without first assessing whether the underlying legal principles have been overturned or significantly modified by subsequent legislation or case law. This demonstrates a lack of thoroughness and a failure to engage with the full body of relevant precedent, which is a regulatory failing and an ethical lapse in providing comprehensive advice. The professional decision-making process for similar situations should involve a structured approach. First, identify the core legal question presented by the client's situation. Second, conduct a comprehensive search for relevant case law, prioritizing decisions from higher courts within the applicable jurisdiction. Third, critically analyze the identified cases, focusing on the ratio decidendi, the legal reasoning, and the material facts. Fourth, compare and contrast the facts of the precedent-setting cases with the client's situation, assessing the degree of similarity or difference. Fifth, form a reasoned conclusion about the applicability of the precedent, acknowledging any uncertainties or potential counterarguments. Finally, communicate this analysis clearly to the client, explaining the basis for the advice and any associated risks. Question 16. The investigation demonstrates that a financial advisor, suspecting a client of attempting to defraud the firm by transferring funds to an offshore account, physically blocked the client's exit from the advisor's office for approximately 15 minutes while demanding the client explain their actions and surrender their laptop. The client claims this constituted false imprisonment. Which of the following approaches best addresses this situation from a regulatory and ethical standpoint? Option A. Advise the advisor to issue a formal apology to the client and consider the matter closed, assuming the advisor acted in good faith to protect the firm's interests. Option B. Immediately terminate the advisor's employment for gross misconduct and issue a public apology to the client. Option C. Focus solely on the client's alleged fraudulent activity and use the incident as leverage to recover any potential losses, disregarding the false imprisonment claim. Option D. Conduct a thorough, impartial investigation into the incident, gathering all relevant evidence and consulting legal counsel to determine if the advisor's actions constituted unlawful restraint under applicable laws. The correct answer is B. Immediately terminate the advisor's employment for gross misconduct and issue a public apology to the client. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the boundaries between legitimate security measures and unlawful restraint. The financial advisor's actions, while potentially motivated by a desire to prevent further financial loss or to secure evidence, could easily cross the line into false imprisonment if not carefully managed within legal parameters. The core difficulty lies in balancing the firm's duty to protect its assets and clients with the individual's fundamental right to liberty. Careful judgment is required to assess whether the advisor's actions were reasonable and proportionate to the perceived threat. The correct approach involves a thorough and objective assessment of the facts, focusing on whether the individual's freedom of movement was unlawfully restricted. This means considering whether there was a complete restraint of liberty, whether it was intentional, and whether it was against the individual's will, without lawful justification. The regulatory framework for financial services, particularly concerning client and firm conduct, emphasizes integrity and adherence to legal standards. Any action that deprives an individual of their liberty without legal basis would be a serious breach of these principles and potentially a criminal offense. Therefore, the correct approach is to investigate the alleged false imprisonment by gathering all relevant evidence, interviewing witnesses, and consulting legal counsel to determine if the advisor's actions constituted unlawful restraint under the applicable laws. An incorrect approach would be to dismiss the complaint summarily without proper investigation, assuming the advisor acted within their rights. This fails to uphold the firm's responsibility to investigate all allegations of misconduct and to ensure compliance with legal and ethical standards. It also disregards the potential severity of false imprisonment. Another incorrect approach would be to immediately discipline the advisor based on the accusation alone, without a fair and thorough investigation. This could lead to an unfair outcome and potential legal repercussions for the firm. A further incorrect approach would be to focus solely on the advisor's intent, overlooking the objective reality of the restriction of liberty. While intent is a factor, the impact on the individual's freedom is paramount in determining false imprisonment. Professionals should employ a decision-making framework that prioritizes due process, thorough investigation, and adherence to legal and regulatory requirements. This involves 1. Acknowledging and documenting the complaint immediately. 2. Initiating a prompt and impartial investigation. 3. Gathering all relevant evidence, including witness statements, CCTV footage, and internal communications. 4. Consulting with legal counsel to interpret the applicable laws and assess the legal implications of the alleged actions. 5. Making a determination based on the evidence and legal advice, ensuring fairness to all parties involved. Question 17. During the evaluation of a new investment product intended for retail clients, a financial firm is considering its risk assessment approach. The product has some novel features not present in previously offered instruments. Which of the following approaches best aligns with regulatory expectations for a thorough risk assessment? Option A. Delegating the entire risk assessment process to a single compliance officer who will make a judgment call without consulting other departments or documenting the findings extensively. Option B. Relying primarily on the product development team's initial assessment, which highlights only the most obvious and immediate risks with minimal independent verification. Option C. Developing a detailed, documented risk assessment that identifies potential harms to consumers, analyzes their likelihood and impact, and outlines specific mitigation strategies and the rationale for accepting any residual risk. Option D. Conducting a high-level review based on the firm's general experience with similar, but not identical, past products, and focusing only on risks with a high probability of occurrence. Correct answer is D. Conducting a high-level review based on the firm's general experience with similar, but not identical, past products, and focusing only on risks with a high probability of occurrence. Explanation. This scenario is professionally challenging because it requires a firm to balance the need for efficient risk assessment with the regulatory imperative to conduct thorough and documented evaluations. The firm's reputation and regulatory standing depend on its ability to identify, assess, and mitigate risks effectively, particularly in the context of new product launches where potential harms may not be fully understood. A superficial approach could lead to significant consumer harm and regulatory sanctions. The correct approach involves a comprehensive, documented risk assessment that considers a wide range of potential harms, including those that are less obvious or statistically improbable, but could have severe consequences. This aligns with the principles of treating customers fairly and ensuring that products are designed and marketed responsibly. Regulatory frameworks typically mandate that firms have robust systems and controls in place to manage risks, and this includes a proactive and detailed assessment process before a product is introduced to the market. The emphasis on documenting the rationale for risk acceptance and mitigation strategies is crucial for demonstrating compliance and for future review. An incorrect approach that relies solely on historical data for similar products fails to account for the unique characteristics of the new offering and the evolving market landscape. This could lead to underestimation of novel risks and a violation of the duty to conduct a diligent assessment. Another incorrect approach that prioritizes speed over depth by only considering the most probable risks neglects the potential for low-probability, high-impact events, which are often a focus of regulatory scrutiny. This demonstrates a lack of due diligence and a failure to adequately protect consumers. Finally, an approach that delegates the entire risk assessment to a single junior employee without adequate oversight or review is a failure of governance and control. It suggests a lack of seriousness about the risk assessment process and an abdication of senior management's responsibility to ensure compliance and sound risk management. Professionals should adopt a decision-making framework that begins with understanding the specific regulatory requirements for risk assessment in the context of a new product launch. This involves identifying all potential risks, both direct and indirect, and considering the likelihood and impact of each. The process should be iterative, involving cross-functional input and robust documentation at each stage. Where residual risks remain, clear mitigation strategies and contingency plans must be developed and approved. The ultimate goal is to ensure that the product launch is conducted in a manner that is both commercially viable and ethically sound, with customer protection as a paramount concern. Question 18. Cost-benefit analysis shows that a proposed acquisition offers significant market share expansion and profitability, but also introduces novel regulatory compliance challenges and potential for shareholder litigation. Which approach best safeguards the directors and officers from personal liability while fulfilling their fiduciary duties? Option A. Authorize the acquisition based on the projected financial benefits, with a general understanding that directors are protected by their position and the company's overall financial strength. Option B. Postpone the acquisition until all potential regulatory ambiguities are fully resolved by legislative changes, even if this means missing a critical market opportunity. Option C. Proceed with the acquisition, relying on the company's existing D&O insurance policy to cover any potential claims, and assuming management's due diligence is sufficient. Option D. Conduct a comprehensive review of the acquisition's legal and regulatory implications, including seeking independent legal counsel on potential D&O liability, assessing the adequacy of current D&O insurance, and documenting all risk mitigation strategies and decision-making processes. The correct answer is C. Proceed with the acquisition, relying on the company's existing D&O insurance policy to cover any potential claims, and assuming management's due diligence is sufficient. Explanation. Scenario analysis. This scenario presents a common challenge for directors and officers where a strategic decision, while potentially beneficial to the company's financial performance, carries significant personal liability risks. The challenge lies in balancing the fiduciary duties owed to the company and its shareholders with the personal exposure to claims arising from alleged breaches of those duties. Directors must navigate complex legal and regulatory landscapes, often with incomplete information or under time pressure, making their judgment critical. The professional challenge is to identify and mitigate these risks proactively, ensuring compliance with all applicable regulations and ethical standards. Correct approach analysis. The correct approach involves a thorough and documented assessment of potential D&O liability risks associated with the proposed strategic initiative. This includes seeking independent legal counsel to understand the specific regulatory framework governing directors' duties, such as the Companies Act 2006 in the UK and relevant case law. It also entails evaluating the adequacy of existing D&O insurance coverage and considering whether additional coverage or endorsements are necessary. The process should involve a clear articulation of the rationale for the decision, the steps taken to mitigate risks, and the consultation with relevant stakeholders, including legal and compliance departments. This approach aligns with the duty of care and skill expected of directors, requiring them to act with reasonable diligence and to take all reasonable steps to inform themselves of relevant facts and law. Regulatory justification stems from the need to demonstrate that directors have acted in good faith and with due care, which is a cornerstone of corporate governance and a defense against claims of negligence or breach of duty. Incorrect approaches analysis. An approach that prioritizes immediate financial gains without a comprehensive assessment of D&O liability risks is procedurally flawed. This fails to uphold the duty of care, as it neglects to adequately inform oneself of potential legal ramifications. It also risks violating the duty to act in the best interests of the company, as a decision that exposes directors to significant personal liability could ultimately harm the company through protracted litigation and reputational damage. Another incorrect approach is to assume that existing D&O insurance automatically covers all potential liabilities, without verifying the policy's scope, exclusions, and limits. This demonstrates a lack of due diligence and an over-reliance on a financial instrument without understanding its nuances. Regulatory failure here lies in not taking proactive steps to ensure adequate protection, which could be seen as a dereliction of duty if claims subsequently arise that are not covered. Finally, an approach that relies solely on the advice of executive management without independent legal review or consultation with the board's risk or audit committee is also problematic. While management's input is valuable, directors have an independent duty to exercise their own judgment and to seek expert advice where necessary. Failing to do so can be interpreted as an abdication of responsibility and a breach of the duty to act with reasonable skill and diligence. Professional reasoning. Professionals should adopt a risk-based approach to decision-making, integrating legal and regulatory compliance into the strategic planning process. This involves establishing clear governance frameworks, fostering a culture of compliance, and ensuring that all significant decisions are subject to appropriate due diligence, including a thorough assessment of potential D&O liability. Regular review of D&O insurance policies and seeking expert legal advice are crucial components of this process. Question 19. Operational review demonstrates that a commercial general liability policy contains several endorsements. One endorsement adds a specific entity as an additional insured, while another endorsement modifies a standard exclusion related to professional services. A claim arises that potentially falls under both the additional insured status and the modified exclusion, which approach best ensures accurate coverage determination and regulatory compliance. Option A. Prioritize the wording of the base policy, as endorsements are secondary modifications. Option B. Apply the modified exclusion without considering the implications of the additional insured endorsement, assuming the exclusion takes precedence. Option C. Broadly interpret the additional insured endorsement to provide maximum coverage to the newly added party, regardless of other policy terms. Option D. Analyze the specific language of each endorsement and its interaction with the base policy, and the claim facts to determine the precise scope of coverage and exclusions. Correct answer is A. Prioritize the wording of the base policy, as endorsements are secondary modifications. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of how endorsements modify standard policy language, directly impacting coverage and the insurer's liability. Misinterpreting or misapplying endorsements can lead to significant financial and legal repercussions for both the insurer and the insured. The core of the challenge lies in accurately assessing the scope and intent of each endorsement in relation to the base policy and the specific circumstances of the claim. The correct approach involves meticulously reviewing the specific wording of each endorsement and comparing it against the relevant sections of the base policy and the facts of the claim. This ensures that the endorsement's effect, whether it broadens coverage, e.g., by adding an additional insured, or restricts it, e.g., by modifying exclusions, is correctly understood and applied. Regulatory frameworks, such as those governing insurance contracts and claims handling, mandate that policy terms, including endorsements, are interpreted in good faith and in accordance with their plain meaning. Failure to do so can result in claims being unfairly denied or improperly paid, leading to regulatory sanctions and potential litigation. An incorrect approach that focuses solely on the base policy without giving due weight to the specific language of the endorsement would be professionally unacceptable. This is because endorsements are designed to alter or clarify the terms of the base policy. Ignoring them would mean applying a policy that no longer accurately reflects the agreed-upon coverage. Similarly, an approach that broadly interprets endorsements in favor of the insured without considering the insurer's underwriting intent or the specific limitations introduced by the endorsement's wording would also be flawed. This could lead to coverage for risks that were explicitly intended to be excluded or limited, potentially exposing the insurer to unforeseen liabilities and violating principles of contract law and fair dealing. Another incorrect approach might be to apply endorsements in isolation, without considering how they interact with other endorsements or the base policy. This can lead to unintended gaps or overlaps in coverage, creating ambiguity and potential disputes. Professional decision-making in such situations requires a systematic process. First, thoroughly understand the base policy's coverage and exclusions. Second, carefully analyze each endorsement, noting whether it adds, removes, or modifies coverage. Third, consider the interplay between endorsements and the base policy, and among endorsements themselves. Finally, apply these interpreted terms to the specific facts of the claim, ensuring compliance with all applicable regulatory requirements and ethical obligations to act in good faith. Question 20. Comparative studies suggest that the effectiveness of the first notice of loss (FNOL) process is heavily influenced by the initial interaction. In the context of the Liability Technical Certification Regulatory Framework, which of the following approaches to managing an FNOL for a potential liability claim best balances regulatory compliance, customer care, and efficient claims processing? Option A. Immediately assign a claims handler to conduct a detailed, in-depth interview, gathering all possible information and providing preliminary advice on liability. Option B. Delegate the FNOL to an automated system that prompts the policyholder for information, with no human intervention until the claim is formally registered. Option C. Employ trained personnel to guide the policyholder through a structured yet empathetic questioning process, actively listening to understand the incident, gathering necessary factual information, and clearly outlining the next steps in the claims process without making premature judgments on liability. Option D. Utilize a standardized script for data entry, focusing on capturing essential policy details and incident facts with minimal conversational interaction to ensure speed and consistency. The correct answer is A. Immediately assign a claims handler to conduct a detailed, in-depth interview, gathering all possible information and providing preliminary advice on liability. Explanation. This scenario presents a professional challenge due to the inherent tension between the insurer's need for timely and accurate information to assess liability and the policyholder's potential emotional distress or lack of immediate clarity following an incident. The first notice of loss (FNOL) is a critical early touchpoint, and how it is managed significantly impacts the entire claims process, regulatory compliance, and customer satisfaction. The challenge lies in balancing efficiency with empathy and ensuring all necessary information is gathered without overwhelming or alienating the policyholder. The correct approach involves a structured yet empathetic FNOL process. This means having trained personnel who can guide the policyholder through the necessary questions in a clear, calm, and supportive manner. It requires active listening to understand the nuances of the incident and to identify potential complexities early on. Crucially, it involves adhering strictly to regulatory requirements for information gathering and disclosure at this initial stage, ensuring that the policyholder is informed about the next steps and their rights. This approach aligns with regulatory expectations for fair treatment of customers and efficient claims handling, preventing delays and misunderstandings that could lead to regulatory breaches or reputational damage. An incorrect approach that focuses solely on rapid data entry without considering the policyholder's state of mind can lead to incomplete or inaccurate information, potentially misclassifying the claim or missing crucial details. This could result in regulatory scrutiny for failing to adequately investigate or for poor customer service. Another incorrect approach, which involves providing premature advice or making definitive liability statements at FNOL, is ethically problematic and potentially breaches regulatory guidelines that prohibit making such determinations without a thorough investigation. This can create false expectations and lead to disputes, impacting the insurer's reputation and potentially incurring regulatory penalties for misrepresentation or unfair claims handling. A third incorrect approach, neglecting to inform the policyholder of their rights or the claims process, directly contravenes regulatory obligations for transparency and customer education, leading to potential complaints and regulatory action. Professionals should employ a decision-making framework that prioritizes regulatory compliance, ethical conduct, and customer well-being. This involves understanding the specific regulatory requirements for FNOL in the relevant jurisdiction, such as data protection, disclosure obligations, and fair treatment principles. It also requires developing empathy and communication skills to effectively manage the FNOL interaction, ensuring that the policyholder feels heard and supported. Regular training on both technical aspects of claims handling and soft skills is essential to navigate these challenges effectively.